Um, Thank you. I'm New York State Attorney General Eric Schneiderman. I'm joined here today by Howard Master, Senior Enforcement Counsel, Anjana Samant from our Civil Rights Bureau, and Amanda Addison, also from our Civil Rights Bureau. I also want to acknowledge the presence today of Sonia Osario from the National Organization for Women, who is with us today. We've been conducting an investigation for more than 4 months into the Weinstein Company, and our investigation, as demonstrated by the petition filed yesterday, uncovered a pervasive pattern of sexual harassment, intimidation, discrimination, and abuse at the Weinstein Company. Women were coerced into facilitating Harvey Weinstein's misconduct. Sometimes they were targets themselves. If they refused, they were threatened with insults. Their careers were threatened. They were threatened with physical intimidation and violence. And the important thing about our investigation is that it is an investigation of the Weinstein Company itself, because any time there is a pattern of sexual harassment, discrimination, or abuse, in addition to the individual perpetrator being liable, the corporation or entity is also liable. And in fact, the board and management knew all of this. TWC entered into numerous settlements with non-disclosure agreements as a corporate entity itself. So the liability extends beyond the individual perpetrator, and it is clear to us, and is set forth in our complaint, that the company's management was complicit in this pattern of misconduct. They knew what was happening. It was flagrant. It was flamboyant. They knew how pervasive it was, and not only did they fail to stop it, they enabled it and covered it up. The COO, David Glasser, who supervised the Human Resources Department, did not stop this discrimination, harassment, and abuse, even though he was in charge of handling dozens of shocking complaints. The board failed to act, and this is critically important. Both the board and management have legal duties to stop this type of misconduct. This is not something that is optional for management or the board of a corporation. Yet management, including the COO and the human resources staff, never launched a single formal investigation into any of the complaints of discrimination, harassment, or abuse, and there were many, many complaints. Yesterday, we finally made clear that by failing to protect its employees, the Weinstein Company repeatedly broke the law. This is unacceptable. It was then, it is now, and it will be moving forward. That's why it is critically important that any deal to buy the company's assets ensure, first, that victims will be adequately compensated, two, that employees will be protected moving forward, and three, that company executives who perpetuated or enabled the pervasive sexual misconduct at TWC will not be rewarded. As of yesterday, there was no deal that would have met these standards. The documents provided to us indicated that the deal on the table would have rewarded David Glasser and other top executives. The deal would have kept victims muzzled by non-disclosure agreements that stopped them from telling their stories. And in the documents provided to us, which we were told were the updated deal documents, there was no victims' compensation fund. Let me make that clear. There was no reference to a victims' compensation fund that was funded for the victims themselves. Instead, we received several insurance policies and were told of a letter of credit, but these were to cover any and all expenses related to sexual misconduct. The funds were not dedicated to the victims. They would have been eaten up by legal fees and other expenses. So if any prospective buyers are truly interested in turning the page and doing right by TWC's employees who were abused for years and victims, which sometimes included employees, they can and will fix these problems with the deal. We will not stand in the way. We did not file for a temporary restraining order or in any way seek to stop a deal from going forward, but whatever deal is consummated has to take into account the serious allegations of our petition and the facts that we set forth in that petition, which are shocking. We have investigated other companies for patterns of sexual discrimination or harassment. We have never seen anything as despicable as what we've seen here. We made it very clear that our three principles are very simple. Victims and employees have to be treated fairly going forward. we don't think that is too much to ask of anyone who wants to continue the work of the Weinstein Company or purchase its assets. So, as set forth in our petition, the conduct really was shocking. There's a lot of language used there that I'm not going to use, but some of the citations to things that Mr. Weinstein said to employees, the pattern of abuse, the use of employees to manipulate his targets or victims of sexual harassment is just really astonishing. The fact that he had a group of employees who were responsible for cleaning up his office after sexual encounters, including returning articles of clothing to the women who left them behind, is really something that should be shocking to anyone. And it is clear that this was done in violation of the law. So we filed our petition. The allegations speak for themselves. We're not opposed to any deal going forward, but any deal has to take into account the fact pattern set forth in our petition and the needs for compensation to victims and protection of employees going forward. And with that, if you tell Amy who you are, we'll answer questions.
Brian Seltzer, CNN. Will you meet with Maria Contreras-Sweet's investor group, and if so, when?
We were told by the attorneys representing Maria Contreras-Sweet that she would not talk to us or meet with us. They asserted that they were somehow being blocked from doing that by the Weinstein Company. Bob Weinstein gave an interview to Deadline yesterday calling that a lie. We'll let them sort it out, but we have not received any cooperation from Ms. Contreras-Sweet or her attorneys.
So you will not meet with them tomorrow?
There's nothing.
They say you were going to meet with them today.
There's nothing on my schedule. There's no meeting that's ever been scheduled. On a deal to close, it was supposed to close on Sunday. She had a very brief conversation with one of our attorneys saying she was going into a meeting, would call back, never called back, and her attorney then said she would not speak further.
You won't meet with them?
I'm not saying I won't meet with them, but there's no meeting been scheduled. There's no effort been made on their part to cooperate with us at all. In fact, their attorney said, why should we talk with you?
Ethan Harvey, WCBS Radio. Bob Weinstein didn't work for Harvey Weinstein. Should Bob Weinstein or any member of the board, anyone in HR, anyone else of the Weinstein Company face criminal charges?
That is something that I'm not going to comment on at this time. This is make clear what this complaint is, or this petition is. This is a civil complaint under New York Executive Law 6312, which enables us to pursue people civilly for pervasive patterns of illegal activity. It is absolutely clear that there were pervasive patterns of illegal activity here. To the extent there is any criminal conduct, we will be referring that to the district attorney's office. Those terms are completely contradicted by the documents produced to us. And the CEO was supposed to be David Glasser, not a female, as last time I checked.
We have the documents.
They're subject to various confidentiality agreements. I think that the sellers were willing to let us see the documents and let them talk with us. I don't think they're willing to let them talk to you.
Are there terms then, if those terms were put in writing, would that be acceptable?
As I said, we have three simple principles that should be embodied in any deal going forward. Adequate compensation for victims has to be secured. Employees have to be protected going forward. Understand that the putting in charge of a newly configured company, the same people who were involved in perpetuating for 12 years this pattern of misconduct, should be unacceptable to anyone who wants to reimagine the company. We don't want those people rewarded. We want employees protected. We want victims compensated. Simple principles that were not in the deal that was presented to us.
There was a response last night from Harvey Weinstein's attorney. I'll just read the very end of it. It says, if the purpose of the inquiry is to encourage reform throughout the film industry, Mr. Weinstein will embrace the investigation. If the purpose, however, is to scapegoat Mr. Weinstein, he will vigorously defend himself. What do you think when Harvey Weinstein's lawyer thinks of him as a scapegoat?
Well, this complaint is it reflects conduct by Harvey Weinstein. But what it really is about is the corporate liability and the involvement of many others in management and the board. This is a complaint because whenever there is sexual abuse, harassment, or discrimination, the individual perpetrator may face liability, but the corporate entity has a legal duty to protect employees. So if you see a complaint against any corporation or against a government entity, the individual perpetrator is named, but the corporate entity or the government entity also has liability. So what we're talking about is a pervasive corporate culture that enabled, encouraged, and sustained years of abusive conduct that should have been shut down by any corporate officers with any sense of integrity.
You said that you wouldn't stop any deal from going forward. Under what conditions would you and could you?
So what we contemplated at one point, when it never came to fruition, was we wanted to get the facts out that were in our petition so that any deal going forward could be done, perhaps in the context of a settlement of the complaint with them agreeing, as other corporations have agreed, to reform their procedures. And there's been, been a lot made of requests we made for information. What we're seeking is really very simple. We want cooperation with our investigation into past misconduct. That's pretty basic. We want to ensure that their policies going forward protect employees. And we want to ensure that there is adequate compensation for victims and that people who participated in or perpetuated this conduct or covered it up are not rewarded by the deal. So that's pretty simple. We are not opposed to a deal. We would like to see some deal go forward. We are prepared to talk to anyone. Our attorneys were trying to talk to the purchasers, and really were shut down. Again, when an attorney for the purchaser says, "Why should we talk to you?" that tells you all you need to hear.
John Bringarter from Debtwire. Has the Weinstein Companies suggested that they may file for Chapter 11? And if they do so, how would you continue to pursue these assets in a bankruptcy scenario?
Well, obviously, that would be subject to bankruptcy law. The desire and intent is expressed to us by the sellers and the purchasers is to avoid bankruptcy if they possibly can. We think that's a worthy aspiration.
Karen Freifeld, Voice. Hi. On what legal basis can you influence the sale, and why did you file the suit yesterday?
Because it seemed to be clear to us that the facts that we had unearthed in our investigation were not known to the purchasers. They may not have been known to some people on the board of TWC. There was an extensive cover-up of a lot of this that took place. Our investigation is ongoing, and one of the things we're seeking is cooperation. If I were trying to purchase the assets of the company, I would want to negotiate a settlement of this complaint as a part of the deal. That's something we have negotiated settlements with other companies that have reformed their policies, instituted, really not that different from what we're requesting here. So the facts here are more shocking and more flamboyant and more egregious in some respects, but companies that tolerate and perpetuate a pattern of sexual discrimination, harassment, or abuse, that's not that unusual, unfortunately, and we've dealt with these situations before. So we are simply trying to get the facts of our complaint factored into whatever deal is structured going forward.
A couple more questions.
Eugene Anson with CBS News. Are you able to quantify the amount of complaints over the years towards the office that we're in?
We obtained a form of Mr. Weinstein's personnel file. We were told that the physical personnel file had gone missing, which is another issue of concern to us. I don't know the number of complaints, but there were certainly dozens of formal complaints and many more informal complaints over the years. And this is important. There was never, in all the years covered by our investigation, and this is a company that operated with Mr. Weinstein at its helm from 2005 to 2017, there was not one actual investigation by the management or human resources into any one of these complaints, which you're legally required to do if you are a company. And you have policies which you are required by law to have prohibiting this form of discrimination, abuse, and harassment. So there was clearly a systemic breakdown in the company's legal obligations, in their compliance with legal obligations. This is what we're trying to get on the table. Whatever happens going forward, we have to ensure that this is all cleaned up, and a deal that leaves, essentially removes the two Weinstein brothers but leaves the rest of management intact, we think should be unacceptable to any of the purchasers who read this petition.
One follow-up question. Just to clarify, can you stop the deal from going through?
We have not filed any application for a TRO to stop a deal going forward. What's happened is I think that the purchasers are now taking into account the facts we've alleged and understand that they probably have more on their hands than they initially realized.
Mike, there was some reporting that you wanted a monitor on the board of directors at the new company and that there was pushback from potential purchaser. Is that true? Was there pushback? Was there a request for a monitor? And what would a monitor do?
No, we requested some independent supervision or monitor or any other mechanism to ensure independence. Our particular concern was having independent supervision of a victim's compensation fund, so it wasn't being supervised. But keep in mind, the deal that was presented to us kept the top TWC management, people who were involved in the, should have taken action to stop this conduct, had a legal obligation to take action to stop this conduct, and actually, it appears, were involved in the perpetuation and cover-up of this misconduct. It would have kept them in place. So with that factor, we wanted some independence to ensure that the victims were compensated and the victim compensation fund was not being administered by perpetrators.
Last question.
To the fund itself, how large a fund would be needed to satisfy your concerns?
Again, we haven't gotten all the documents to tell us that. We have been frustrated in that effort. We've requested documents from the purchasers and had a very hard time getting documents from them. So we don't know how to quantify it. We do think that the insurance policies that were proffered to us and the notion of the suggestion of a $10 million letter of credit were inadequate because they had to cover all expenses, including legal fees, including everything else. We'd like a fund that is dedicated specifically to the compensation of victims alone. Other companies have done this, set up systems for mediation in some cases. This is not, we're not asking for anything that has not been done in other cases. The facts here are just more shocking and flamboyant. The solutions have been tried and proven to be effective in other situations.
We're talking hundreds of millions of dollars, though, maybe into $1 billion range?
I don't think it would go that high, but it certainly would require more than was on the table as of the time the deal documents were presented to us. Again, we were told these were updated deal documents. We can't verify that.
Thanks, everyone.
Thank you.